I was walking past a bank branch yesterday, all glass walls, very serene, the nice potted plants. And it really struck me how different the reality of finance is from, say, the movie version of finance.
Oh, completely.
When most people think about investing, the image that pops into their head is usually something pretty kinetic.
Mm-hmm.
It's, stock tickers flashing red and green, people shouting on a trading floor in New York, or maybe just someone quietly clicking buy on an app and hoping to become a millionaire by Tuesday. It feels like an action movie.
It really does. It feels like the Wild West sometimes. High stakes, quick draws, winner takes all. The narrative we're all fed is about the risk and the reward, the adrenaline of the trade.
Exactly. But the reality, and this is something we are going to realize very quickly today, is that the financial world, specifically the Canadian mutual fund industry, it isn't the Wild West at all.
Not even close.
If anything, it's the exact opposite. It's actually one of the most heavily architected, patrolled, and rule-bound environments on the planet. It's less Wolf of Wall Street and more.
Well, a really intense library where everyone is watching you to make sure you put the book back in exactly the right spot.
That is a surprisingly accurate analogy.
Yeah.
And it's that way for a very, very good reason.
Right.
Because at its core, this entire industry operates on a single currency.
Mm-hmm.
And I don't mean dollars or Bitcoin or, gold bars. I mean
Okay.
trust.
Trust. Okay, it sounds a little bit like a greeting card, doesn't it? Trust is our currency. But you mean that literally.
I do.
Okay?
Think about it. If you hand your life savings over to a stranger, someone you might have met for an hour in a nice office or maybe just spoke to over Zoom, you need more than just a firm handshake and a nice suit.
You need a guarantee.
You need a guarantee.
Yeah.
You need to know there is a massive, intricate machine in the background designed to keep that money safe and, perhaps more importantly, to keep that advisor honest. And that is exactly what we're unpacking today. We are taking a massive stack of material from the Canadian Investment Funds course, specifically Unit 1 and Unit 2, and we're going to decode the alphabet soup of Canadian financial regulation.
It can be incredibly overwhelming at first glance. I mean, if you just look at the table of contents, you have acronyms like MFDA, IROC, CSA, FinTrack, OBSI, AMF.
Right.
It looks like someone just spilled a bag of Scrabble tiles on the floor and decided to make laws out of them.
It really does. But our mission today is to turn that scattered pile of letters into a clear map. We're going to walk through the journey of a dealing representative, that's the technical term for a mutual fund salesperson, from the government bodies that grant their license to the ethical codes that dictate how they have to behave every single day.
And strictly speaking, our source material is the text that's actually used to train these professionals. So we aren't just reading the marketing brochure. We are looking at the rule book from the inside out. We're seeing the constraints they operate under.
Right. So whether you're an aspiring advisor prepping for an exam and sweating over these acronyms, or you're an investor who just wants to know who is actually watching my money.
This deep dive is for you. We're going to see what happens when things go wrong, and more importantly, how the system is designed to stop things from going wrong in the first place.
So should we start at the top of the pyramid?
Let's do it. Segment 1, the architects and the police.
A fitting title, because we really do have both of those roles here.
So help me understand the landscape here. If I'm in the United States, I hear about the SEC, the Securities and Exchange Commission. It's this massive federal body that everyone fears. If Elon Musk tweets something wrong, the SEC is there. Does Canada have a Canadian SEC?
The short answer is no. And this is a fundamental difference in Canada that confuses a lot of people, even people who live here.
Okay.
In Canada, securities regulation is primarily a provincial responsibility, not a federal one.
Wait, really? So every province is doing its own thing? That seems incredibly fragmented for a national economy. We are one country, aren't we? We are, but we are a federation. It's rooted in the Constitution Act. Property and civil rights are provincial jurisdictions. And securities, stocks, bonds, mutual funds, they're considered property.
Ah, okay.
So we have what are called securities regulators or securities commissions in each province and territory. If you are in Ontario, you deal with the OSC, the Ontario Securities Commission. In British Columbia, it's the BCSC. In Alberta, the ASC.
Okay, but purely from an efficiency standpoint, isn't that a nightmare? If I'm a big bank or a national investment firm, do I have to follow 13 different rule books? Do I need 13 different lawyers?
It creates friction, certainly. I mean, historically, it was a major headache, but we have to respect the power of these bodies. These provincial commissions are incredibly powerful.
How so?
Well, their mandate is strictly defined. protect investors from unfair practices, promote fair and efficient capital markets, and reduce systemic risk. They are the ones who actually have the power to grant or revoke a registration. So if you break the rules in Alberta, it's the Alberta Securities Commission that comes knocking on your door, not a federal agent from Ottawa.
So if I'm an advisor in Ottawa, right on the border of Quebec, and I have clients in both Ontario and Quebec, I'm answering to two different bosses.
In theory, yes. But the industry realized a long time ago that having 13 completely isolated islands of regulation would just strangle the economy.
Sure, capital needs to flow freely.
Exactly. And that is why we have the CSA.
The Canadian Securities Administrators.
Correct. Now, it is important to be precise here. The CSA is not a regulator itself. You can't get a fine from the CSA. They don't have a police force. They don't have a jail.
But what are they? A social club. A coffee group for regulators.
Think of it more as a high-stakes roundtable or a forum. It's
Yeah.
where all the provincial regulators sit down together to harmonize the rules. They realized that if the rules in British Columbia were totally different from the rules in Nova Scotia, nobody could do business nationally.
Right.
So they created something called the passport system.
I like the sound of that. It implies easy travel. How does it work?
Ideally, it means that a market participant, like a firm or advisor, can have access to capital markets in multiple jurisdictions by dealing only with their principal regulator.
So my home base regulator.
Exactly. If your head office is in Toronto, the OSC is your principal regulator. Through the passport system, if you meet the OSC's requirements, the other provinces generally accept that. It harmonizes the laws, so you don't have to reinvent the wheel every time you cross a provincial border.
That makes sense. It's kind of like a driver's license. If I get my license in Ontario, I can still drive in Manitoba without taking a new road test.
That is a perfect analogy. The rules of the road are harmonized enough that one license is valid everywhere. That's the goal.
Okay, so the provinces are the heavy hitters with the legal power, and the CSA is the club where they agree on the rules so the country doesn't fall apart.
Yeah.
But then we have these other acronyms that seem to do the heavy lifting on the ground, the SROs.
The self-regulatory organizations. This is a crucial distinction, and it's one that often makes the public skeptical.
Well, yeah, self-regulatory. It sounds like letting the fox guard the henhouse, doesn't it?
It does.
You know, don't worry, we investigated ourselves and found we did nothing wrong.
It sounds like that, I admit. And it requires a bit of a leap of faith.
Right.
But the logic is that the industry itself possesses the technical expertise to monitor its own members more effectively than a general government bureaucrat could.
Okay, I can see that.
The financial world is complex. You need experts to police experts. But, and this is a big but, they operate under the strict supervision of those provincial commissions we just talked about.
So they're on a leash.
A very tight leash. The government delegates the power, but they watch the SROs like a hawk. If the SRO fails, the government steps back in.
So who are these SROs? Who are the beat cops?
In the world we are discussing today, the mutual fund world, the big player, at least outside of Quebec, is the MFDA, the Mutual Fund Dealers Association of Canada.
Okay, so if I walk into a bank branch or a dedicated financial planning office to buy a mutual fund, that dealer is likely a member of the MFDA.
Exactly. The MFDA regulates their operations, their business conduct, and their capital requirements. They are the ones who will audit the firm. They admit members, and they perform compliance reviews.
So if a dealer is doing something shady,
The MFDA has the power to fine them, suspend them, or terminate their membership.
and without membership, you can't sell.
Precisely. You are out of business. It's an exclusive club, but the condition of entry is following the rules. Now, we have to distinguish this from the other big club, IROC,
IROC.
the Investment Industry Regulatory Organization of Canada.
And IRC is for the stockbrokers, right? The people selling individual equities and bonds.
Generally speaking, yes. IROC regulates investment dealers. These are the full-service firms. They can sell mutual funds too, but they can also sell stocks, bonds, options, futures, the whole menu.
I see.
MFDA members are restricted. They can sell mutual funds, but they generally cannot sell you shares of Apple or Tesla directly.
So MFDA is the specific lane for mutual funds. IROC is the wider highway.
Got it. Now, you mentioned outside of Quebec earlier. I know Quebec often has its own way of doing things in the legal world because of the civil code versus common law distinction. What's the setup there?
Quebec is unique, and if you are operating there, you really need to know this. They have two main bodies. First, the AMF, Autorité de Marché Financier.
Okay.
The AMF is the overarching regulator, similar to the provincial commissions we discussed, but it has a very broad scope. It covers insurance, securities, everything. It's a bit of a super regulator.
So that's the big one. And the second?
Then they have the CSF, the Chambre de la Sécurité Financière. The CSF is interesting because it focuses specifically on the individuals.
On the people, not the companies.
Right. It oversees the training, ethics, and discipline of the representatives. So while the AMF watches the market structure, the CSF watches the people.
So if a representative in Quebec acts unethically, they answer to the disciplinary committee of the CSF. Exactly. It's a dual structure that puts a heavy emphasis on professional conduct and ethics.
I want to touch on one more safety net feature before we move on. We've talked about regulators who make rules, but what happens if the dealer itself goes bust? Not if my investment loses money, because markets go up and down, but if the firm I'm dealing with just collapses or goes insolvent.
That is a terrifying scenario for an investor. You log into your account and the website is down, the doors are locked, and the company is bankrupt.
Yeah.
That is where the protection funds come in. For MFDA members, there is the MFDA Investor Protection Corporation, or IPC.
And what does that actually cover? What does it protect?
It covers eligible customer losses if a member firm goes insolvent. The coverage is up to $1 million for general accounts and another $1 million for retirement accounts.
That's substantial.
Oh.
But I want to be crystal clear here, because I think listeners might misunderstand this part. If I buy a risky mutual fund, let's say a fund that invests in volatile tech startups, and the market crashes, and my $100,000 becomes $50,000, the IPC does not give me a cent, right?
Correct. Huge, huge distinction. And thank you for making that clear. That is market risk. You signed up for that when you invested.
Oh, wait.
The IPC covers insolvency of the dealer. It covers the scenario where you had $100,000 in cash or assets held by the firm, and the firm essentially lost it, stole it, or went bankrupt while holding it. It protects custody, not performance.
So it's like a bank robbery versus a bad bet. If the bank gets robbed, you're covered. If you bet on a losing horse, you are not.
That is a perfect way to put it.
Clear enough. Before we move on from the regulators, there are two other bodies mentioned in the source material that play specific roles. OSFI and OBSI. They sound like siblings.
They do, but they have very different jobs. OSFI, the Office of the Superintendent of Financial Institutions, is federal. They are the big guns who regulate the banks and insurance companies to make sure they remain solvent.
Right.
They don't regulate mutual fund dealers directly, but they are a massive part of the Canadian financial stability architecture. If a big bank fails, that's an OSFI problem.
And OBSI, the other sibling.
OBSI is the Ombudsman for Banking Services and Investments. They are the dispute resolvers. Let's say you have a complaint against your advisor. You claim they lost your money through negligence. Maybe they bought something you explicitly told them not to.
Okay.
You complain to the firm, and the firm investigates itself and says, no, we didn't do anything wrong. You are at a stalemate.
So normally I'd have to hire a lawyer and go to court, which sounds awful.
You could, but that's expensive and takes years. Instead, you can go to OBSI. They are an independent third party. They look at the case, and if they find in your favor, they can recommend a settlement of up to $350,000.
That's a powerful tool for the little guy. It really levels the playing field, so you don't need a corporate legal budget to get justice.
It is. It balances the power dynamic. It ensures that the firm can't just wait you out or bury you in legal fees.
So we have the police, the commissions, we have the clubs, the SROs, and we have the judges, OBSI. But what are the actual laws? The source material talks about national instruments. This brings us to segment 2. The rule book.
Right. Remember the CSA, that group of regulators harmonizing things?
Yeah, the round table.
When they agree on a rule that applies across the country, it becomes a national instrument, or NI.
And there seem to be 4 big ones that expiring advisors really, really need to memorize.
The big 4, we can call them. And it's a good idea to break them down because they essentially govern the life cycle of the investment. First, NI 31103.
31103. The numbers aren't exactly catchy, are they?
No, financial regulators aren't known for their marketing flair, but the content is vital. This is the registration rule. It answers the question, who is allowed to sell?
Okay.
It sets the proficiency requirements, the capital requirements for firms, and the general duties of a registrant. If you want to be in the game, 31103 is your entry ticket. It's your driver's license. It says you have studied enough and are honest enough to handle other people's money.
Okay, so that's the do. Next up, NI 81101.
This is the disclosure rule. Think of mutual funds as a product. Like a box of cereal, they need an ingredients label. You can't just sell mystery box A. 81-101 mandates that investors must receive specific documents like the fund facts document and have access to the simplified prospectus.
So it ensures you know what you are buying.
Exactly. And we'll talk more about fund facts later, but that's the short, easy-to-read document, right? The Coles Notes version.
The one people might actually read.
The one people might actually read. Before this rule, you had to wade through a prospectus that was hundreds of pages of dense legalese. Nobody read it. Literally nobody, except maybe the lawyers who wrote it. 81-101 recognized that disclosure is useless if it's unreadable, so it mandated the fund facts, a plain language summary, no more than a few pages double-sided.
Good. Then we have NI 81-102.
The operations rule. This tells the mutual fund manager what they can and cannot do with the money. It sets limits.
Guardrails.
Perfect word. For example, a mutual fund generally cannot put 100% of its assets into one single stock. That would be insane. It sets rules on borrowing money, on short selling, and on how the fund is bought and sold. It's the mechanics of the engine to ensure the fund doesn't take reckless risks that the investor isn't aware of.
It prevents the fund manager from going to the casino with the client's money.
Essentially, yes. It defines what a mutual fund is and keeps it within those guardrails.
And finally, NI 81-105.
Yeah.
This one seems spicy. Sales practices.
This one is vital. It deals with conflicts of interest in how funds are sold. It prevents fund companies from essentially bribing advisors to sell their funds over others.
Bribing. That feels like a strong word for the financial industry.
Well, historically, it was the reality. I mean,
Right.
go back 20 or 30 years. You might have seen things like mutual fund companies taking advisors on lavish trips to the Caribbean,
Right.
conferences that were basically just golf tournaments,
Right.
or giving them excessive promotional items, or creating complicated commission structures that incentivize the sale of their fund over a competitor's, regardless of whether it was good for the client.
So, sell $1 million of our fund and we'll fly you to Tahiti.
Exactly. And human nature being what it is, that influences behavior. Even if the advisor thinks they're being objective, if one company treats them like royalty and the other doesn't, they might lean toward the royal treatment.
Of course.
NI 81-105 clamps down on that. It ensures that sales incentives don't cloud the advisor's judgment. It strictly regulates what kind of promotional items are allowed. Basically cheap marketing stuff like pens and mugs, and bans the big incentives.
It's reassuring to know there's a specific law just to stop advisors from being wined and dined into bad decisions.
It connects back to that core theme, trust. The client needs to trust that the recommendation is based on their needs, not on which fund company offered the advisor a better golf trip or a fancier dinner.
Absolutely. Now, speaking of bad actors, let's move to segment 3. This is where the source material gets a little cinematic. The detectives. Financial crime and money laundering.
This is a huge part of the regulatory environment today. The legislation is the PCM-LTFA.
That is a mouthful.
It is. The Proceeds of Crime, Money Laundering, and Terrorist Financing Act.
Catchy.
Not exactly, but its purpose is deadly serious. It is designed to detect money laundering, which is the process of taking dirty money from criminal activities and making it look clean, and to stop the financing of terrorist activities.
I think most people have a vague idea of money laundering from shows like Breaking Bad or Ozark.
Yeah.
But how does it actually apply to a mutual fund advisor? Why are they involved? They aren't drug dealers.
Because financial advisors are the gatekeepers. They are the front door to the legitimate financial system.
Okay.
If you are a criminal with $1 million in cash from selling drugs, you have a problem. You can't spend it on a house or a car without raising red flags. You can't just walk into a Lamborghini dealership with a duffel bag of cash anymore. You need to get it into the legitimate financial system. You need to place it, layer it through various transactions to hide its origin, and then integrate it back as clean money.
And a mutual fund account is a good place to do that.
It can be. You buy some funds, hold them for a bit, maybe sell them and move the money to a different account, maybe transfer it to an offshore account. Suddenly, the money looks like investment proceeds, not drug money.
I see.
The source material makes it clear. Advisors are on the front lines of this war. They are deputized to stop this.
And the agency they report to is Track.
The Financial Transactions and Reports Analysis Center of Canada. Track is the intelligence unit. They don't arrest people. They aren't the RCMP. But they gather the data that helps the police build cases. They look for patterns across the whole banking system.
So what does an advisor actually have to do? They aren't private investigators. They can't wiretap their clients.
No, but they have strict reporting requirements. First, suspicious transactions. If a client is trying to do something that just doesn't make sense, like moving money in a circle for no reason, or being weirdly secretive about the source of
Or
funds.
asking, does this get reported to the government? That seems like a giveaway.
That's a huge red flag. The advisor must report it.
Even if they don't go through with the trade.
Yes. Even if it is just an attempted transaction, if someone comes in, asks sketchy questions, and then leaves when you ask for ID, you still have to report that attempt.
If you smell smoke, you call the fire department.
Exactly. And you don't tell the client you reported them, right? Hey, just so you know, I told the feds about your weird cash.
Absolutely not. That is tipping off, and it is a federal crime. You file the report silently and let the authorities handle it. If you tip them off, you are obstructing an investigation.
And then there are large cash transactions.
Right.
Any cash transaction of $10,000 or more in a single 24-hour period must be reported.
$10,000 is the magic number.
Yes. Though, frankly, in the mutual fund world, actual cash bills is rarely accepted anymore precisely because of this risk. Most dealers just say, no cash allowed, bring a check or a bank draft. But the rule stands.
This brings us to a term every investor has heard, KYC, know your client. Usually we think of this for investment suitability like, are you conservative or aggressive? But here it's about identity.
Correct. KYC is your shield against money laundering. You must verify who the person is. You need to see a passport, a driver's license. You need to know their occupation. You need to know where the money is coming from.
Right.
If a 20-year-old student wants to invest $500,000, you need to ask how they got it. Is it inheritance? Or is it something else? You have to ask.
There was a really interesting nuance in the source text about health cards.
Yes, this trips people up all the time. A
Yeah.
client pulls out their health card as ID. In many provinces, specifically Ontario, Manitoba, and PEI, you generally cannot use a provincial health card for identification purposes.
Why is that? It's a government ID with a photo. It seems perfect.
It's because of privacy laws regarding health information. The regulations restrict the collection of that specific number to protect your medical privacy. The health number is the key to your medical history, so the government wants to limit who has it.
Okay, that makes sense.
However, the text notes a quirky exception. In Quebec, you can ask for it, but if the client volunteers it, you can accept it.
That is a very Canadian nuance. I can't ask, but if you offer.
It is. It's a delicate balance between privacy and verification, and then there's the no ID protocol. This is crucial.
What's that?
If you can't identify the person, say their license is expired or they forgot it, you might be able to take the money in to secure a price for a trade that day, but you absolutely cannot transact fully or give the money back until the ID is confirmed.
You freeze the assets.
You essentially freeze the assets. It's like a purgatory for unverified money. We can't let the money leave until we know who you are.
And then we have the VIPs,
PPs.
politically exposed persons.
This sounds like the cast of a political thriller. It refers to people who hold high public office, heads of state, generals, ambassadors, judges, or their close family members.
Why are they flagged? Are we assuming they are criminals?
No, not at all. But we are assuming they are at a higher risk for bribery and corruption. If a foreign general from a country with a high corruption index suddenly wants to invest $50 million in a Canadian mutual fund, you need to ask where that money came from.
Right.
It might be legitimate family wealth, or it might be a bribe from a defense contractor. Advisors have to determine if a client is a PP when opening an account.
It's fascinating how the advisor is essentially the eyes and ears of the state. It's not just about picking stocks, it's about national security.
It's the price of entry for the profession. You are a steward of the financial system. If you let dirty money in, you pollute the whole stream.
Moving on to segment 4. We've dealt with criminals, now let's deal with something perhaps even more annoying. Spam and the IRS.
A different kind of headache, but a headache nonetheless.
Let's start with privacy.
Mm.
PIPEDA.
The Personal Information Protection and Electronic Documents Act. This is the federal law that governs how private sector organizations handle your data.
And personal information is defined pretty broadly, isn't it? It's not just social insurance number.
Very broadly. It's your name, address, age, weight, income, blood type, your opinions, your social status, basically any factual or subjective information about an identifiable individual.
So what isn't personal info?
Business card information, your name, your job title, your business address, and phone number. That is considered public enough that it doesn't fall under the same strict protections. You can hand out business cards without signing a privacy waiver.
So the rule for advisors is simple. Collect only what you need, get consent, and keep it safe.
Simple in principle, complex in execution. Data breaches are a massive liability now. If an advisor loses a laptop with client data, that is a PIPEDA disaster.
Now, telemarketing. The do not call list.
Yeah.
I think we all wish this worked perfectly, but for advisors, it's a strict rule.
The DNCL. If a number is on that list, an advisor cannot make a cold call to try and sell them services. They just can't do it, period.
But there are loopholes, right? Everyone seems to get calls.
There are exceptions. The biggest one is the existing business relationship. If you are already a client, your advisor can call you. That makes sense. You want them to call you.
Sure.
But it also applies if you were a client recently. Up to 18 months after the business relationship ended, say you closed your account, they can still call you to try and win you back.
18 months, that's a long breakup period. I know we broke up a year and a half ago, but I've changed, baby.
It is, but once that 18 months is up, if you're on the DNCL, they have to stop. If they don't, the fines are hefty.
Then there's CASL, Canada's anti-spam legislation. This is about emails and texts.
And this is one of the toughest anti-spam laws in the world. The core concept is opt-in, meaning silence is not consent. You cannot have a pre-checked box on a website that says, sign me up for the newsletter, where the user has to uncheck it to avoid the spam.
Ah, the old trick.
That used to be the standard trick. CASL banned it. The user must actively click the box. They must ask for the email.
And if an advisor sends me a spam email,
You must be able to unsubscribe easily, one click. And if they break the rules, the penalties are astronomical, up to $1 million for individuals and $10 million for organizations.
$1 million for sending spam, that's serious.
It shows how serious the government is about digital clutter and privacy. There is a referral exception, though, which advisors use a lot.
Okay, what's that?
If you and I have a mutual friend, and that friend suggests I contact you, I can send you one single email introducing myself.
Just one.
Just one. If you don't reply, I can't follow up. I can't circle back. I can't just checking in. I get one shot.
One shot, make it count.
Exactly.
Okay, finally in this section, the TICA, the Foreign Account Tax Compliance Act. This isn't even a Canadian law, really. It's American. Why are we talking about it in a Canadian course?
Because the United States is one of the few countries that taxes its citizens on their worldwide income, regardless of where they live.
Right.
If you are a U.S. citizen living in Toronto, never planning to go back to the States, you still owe the IRS tax returns. FECA is the U.S. forcing the rest of the world to help them collect those taxes.
Forcing seems like a strong word.
It's accurate.
Yeah.
The U.S. government basically said to Canadian financial institutions, if you don't tell us about the accounts held by U.S. persons, we will slap a 30% withholding tax on any U.S. source payments flowing to you.
Ouch. So if a Canadian mutual fund holds Apple or Microsoft stock and receives dividends, they could lose 30% of that income if the dealer isn't compliant.
Correct. That would destroy returns for everyone, not just the Americans. So Canadian dealers had no choice. They have to ask clients, are you a U.S. person?
And a U.S. person isn't just a citizen.
It's citizens, green card holders, or people with substantial U.S. ties, like a U.S. address or phone number. If you are a U.S. person, your account details get sent to the Canada Revenue Agency, CRA, and the CRA hands them over to the IRS.
And what if I refuse to answer, if I say, none of your business?
The dealer has to report you to the CRA anyway as a refusing account, and the IRS gets notified. There is really no place to hide. It created a lot of controversy, but it is the law of the land now.
The long arm of the law, indeed. Let's move to segment 5. We've talked about laws, but now let's talk about values, the moral compass, ethics, and compliance.
This is my favorite topic because it touches on the gray areas. The laws are black and white, but life is often gray.
The source material makes a distinction between ethics and regulations. How do you distinguish them? Aren't they the same thing?
Not quite. Regulations are the written rules. Do not drive over 100 kilometers. That is a binary rule. You are either speeding or you aren't. Ethics are the principles of conduct, the values. Drive safely so you don't hurt anyone.
So you can be unethical without breaking a specific law.
Absolutely. The example in the text is using office computers for personal tasks against company policy. That's unethical. You are misusing resources. It's not illegal. The police won't arrest you. But it violates the code of conduct.
And clearly you can be both unethical and illegal.
It's like stealing client funds. That violates the value of honesty and the criminal code against theft. But the tricky part, the real test, is where something is legal but unethical.
The MFDA has a specific rule for this, Rule 2.1.1. It seems to be the catch-all.
The standard of conduct. It is the golden rule of advising. It says, each member and each approved person shall deal fairly, honestly, and in good faith with its clients.
Fairly, honestly, and in good faith. It sounds simple, but it covers so much.
It covers everything the specific rules might miss. It means you follow the spirit of the law, not just the letter. You don't try to find a loophole to screw over a client.
Right.
If you technically followed the rule but you knew the client would be harmed, you violated Rule 2.1.1. It's the ultimate safety net for client behavior.
To ensure this happens, firms have a compliance regime. Who are the key players here? I feel like compliance departments get a bad rap. People think of them as the business prevention department.
They do, and that's unfair. They are actually the support system. They help manage risk. If an advisor goes rogue, the whole firm's reputation is destroyed. Compliance is there to protect the firm and the clients. They are not just police, they are coaches.
So who runs the show?
At the very top, you have the UDP, the ultimate designated person, usually the CEO. They are responsible for the overall culture of compliance. The buck stops with them. You can't just say, I didn't know.
And then?
Then you have the CCO, the Chief Compliance Officer. They are the architect. They write the policies, they monitor the firm, and they report to the board. They're the ones checking the trade logs.
The text mentions some specific prohibited practices that compliance looks out for. Two stood out to me because they seem so easy to fall into. Pre-signed forms and excess trading. Let's talk about pre-signed forms. Why is this such a big deal?
This is a classic trap. Picture this. Your client is going on vacation for a month to a cottage with no internet. They say, hey, if the market drops while I'm gone, I want to buy. Here, I'll sign a blank trade form now. You just fill in the details later if we need to.
It sounds convenient. Helpful, even.
Yeah.
The client is asking for it.
It does. But it is strictly forbidden. Zero tolerance.
Why?
Because a blank signed form is a blank check. It creates a massive opportunity for fraud. An advisor could fill in anything, even if the advisor is honest this time. It invalidates the paper trail of instructions. If the client later says, I didn't authorize that, and the form shows it was signed 3 weeks before the trade details were filled in, the firm has no defense.
So never ever do it, even if the client begs you.
Never. Get the signature after the details are filled in or use electronic authorization. Just don't use pre-signed paper.
And excess trading.
Also known as churning. This is when an advisor buys and sells funds in a client's account just to generate commissions, not because it benefits the client.
Because every trade might trigger a commission for the advisor.
Exactly. If you see a portfolio turning over 100% every month, selling everything and buying new stuff constantly, that's a huge red flag. The compliance officer will see that on a report and ask, why are we doing this? The only person making money here is the advisor. It's stealing from the client via fees.
That leads us perfectly into our final major segment. Segment 6, the modern advisor. This is about how the industry's evolved towards transparency. We have these acronyms, CRM and CFR.
The client relationship model, CRM, and the client-focused reforms, CFR. These are the biggest changes in the industry in the last decade. It's all about sunlight.
It seems like the goal is to make sure the client actually understands what they're paying for.
Precisely. It started with CRM. It introduced the concept of RDI, relationship disclosure information.
The user manual for the account.
Yes, that's a great way to put it. Before you trade, the dealer must give you a document that explains, what kind of account is this? How are we paid? What are the risks? How do we handle conflicts of interest?
It puts it all on the table.
It also mandates benchmarks. You can't just say, you made money. You have to compare it to something. If your fund made 5%, but the market made 15%, you didn't do a good job. CRM forces that comparison so the client knows if the performance is actually good.
And then came CFR client-focused reforms. This sounds like it should have been the standard all along. What did that add?
It added the client-first standard. It explicitly states that registrants must put the client's interest first when making suitability determinations.
Wait, wasn't that always the rule?
You would hope so. But previously, the standard was often just suitability. Is this fund suitable for you? Yes. Is it the best one for you? Maybe not. Maybe it pays me a higher commission, but it's still suitable.
So good enough was good enough.
As long as it was suitable, it was allowed. CFR changed that. If there is a conflict like one fund paying more commission than another, it must be addressed in the client's best interest. The advisor essentially has to ask, is there a cheaper or better option for the client? If there is, they should recommend that one, even if they make less money.
That is a subtle but massive shift. It moves from, can I sell this, to, should I sell this?
It is. It's a huge shift in mindset. And the reporting requirements got stricter too. We now have the report on charges and compensation.
This is the one I love.
It's a game changer. Once a year, every client gets a report that shows exactly how much the dealer was paid in dollars and cents. Not 2% MER, which sounds abstract. It says, you paid us $1,250.
Seeing that number in real currency really wakes people up.
It drives value conversations. The client asks, I paid you $1,250. What did I get for that? And the advisor better have a good answer planning advice service. If the answer is, I just picked a fund, the client might leave. It forces advisors to prove their worth.
And there's pre-trade cost disclosure too, right?
Yes. Before the advisor pushes the button to buy, they have to tell you what it will cost. No surprises later.
So bringing it all together, we've gone from the provincial regulators to the national rules, through the anti-money laundering screens, past the privacy laws, and right down to the specific email the advisor sends you with the bill.
It is a dense web.
But as we wrap up, I want to go back to that why. Why do we have all this?
It's what we said at the beginning, trust, but it's also history. Every one of these rules, the ban on pre-signed forms, the cash reporting, the disclosure requirements, is usually a reaction to a past failure.
Right.
Someone got hurt, money was lost, trust was broken, and a rule was written to prevent it from happening again.
The architecture is built on the lessons of the past.
Exactly. These aren't just bureaucratic hurdles. They are protections for your future assets.
I want to leave our listeners with a thought that came up in the source material, almost as a side note, but it feels huge. The text mentions older and vulnerable clients as a specific lesson.
Yes, Lesson 6 in Unit 3. It's a growing area of focus.
We have an aging population. We have this massive web of rules, disclosures, RDI documents, fun facts. Does a 90-year-old client with declining cognitive health actually benefit from receiving a 40-page disclosure document?
That is the provocative question, isn't it? We have built a system on disclosure, on giving people information. But if the client is vulnerable or can't process that information, is disclosure enough?
Or is it just a legal shield for the company?
Or do we need to move from disclosure to something more protective? The trusted contact person rules are starting to address this, but as the great wealth transfer happens and our population ages, I think we are going to see the regulations have to adapt again. The paper trail might not be enough to protect someone who can't read the map anymore.
That is a fascinating challenge for the next generation of regulators.
It is a massive one.
Well, on that note, we hope this deep dive helped you decode the rules of the game. Whether you are studying for your exam or just checking your own investment statements, knowing the rules helps you play better.
Read the fine print. It matters.
Thanks for listening. We'll catch you on the next deep dive.